Good morning.
Morning, Your Honor. Morning, Your Honor.
Let me call the case 19-51291, Giga Entertainment Media, Inc. Appearances, please.
Pat McKinstry and Robert Rutherford for the debtor, also present is James Massa, principal of the debtor.
Good morning.
David Schrader and Elizabeth Alpin on behalf of the movements.
Good morning.
Morning, Your Honor. Jessica Middendorf for the trustee.
Good
Jim
morning.
Lyman, trustee.
All right, anyone else present? All right, the court scheduled this continued hearing in follow-up to the evidentiary hearing to deliver her ruling to the parties. Pending in this district is a voluntary Chapter 7 case filed by debtor Giga Entertainment Media, Inc. I will refer to this entity as debtor, Giga, or GEM. The case is before the court on a motion for a determination that venue is improper and to transfer venue filed by Bob Barnard, William Freeman, Patricia Gilchrist, Lyle Gilman, Arthur Mellon, Gary Nerlinger, David Shutbett, and Reva Wilkins, which is at docket number 18. I will refer to these parties as the movements. Debtor filed a response to the motion at docket number 23. The Chapter 7 trustee also filed a response to the motion at docket number 24. The court held an evidentiary hearing on September 17th. And the following will constitute the court's findings of fact, conclusions of law. 28 U.S.C. Section 1408 is the statute that governs venue in a bankruptcy case. It provides that venue can be proper under 4 bases, including where the debtor's principal place of business is located. Under Section 1408(1), venue is proper where the principal place of business exists either for the 180 days before filing or for, quote, a longer portion of such 180-day period than in any other district, end quote. In accordance with Section 1408, based on the filing date of GEM's petition, the pertinent 180-day time period here is between December 29th of 2018 and June 27th of 2019. I may refer to this as the venue period. While certain relevant actions occurred outside of the venue period, the court is required to focus primarily on facts within the venue period. Movements argue that venue is improper in the Eastern District of Kentucky. They invoke 28 U.S.C. Section 1406 and Bankruptcy Rule 1014A2, which provide that if a bankruptcy case has been filed in the wrong district, the court should dismiss the case or, if it is in the interest of justice, transfer the case to any district in which it could have been brought. Movements contend the court should transfer venue of this bankruptcy case to the Southern District of New York. The burden on this motion falls on the movements. They must establish by a preponderance of the evidence that the debtor's chosen venue is improper. Movements also face a presumption that the debtor's chosen venue is appropriate. Citing in support the Miller case at 433 BR 205, a bankruptcy case out of the Western District of Michigan in 2010. Both parties have cited the nerve center test for determining debtor's principal place of business. The United States Supreme Court interpreted the term principal place of business in connection with how that term is used in 28 U.S.C. Section 1332C1, which concerns diversity jurisdiction over corporations. The Supreme Court adopted the nerve center test. That's Hertz Corporation versus Friend, 559 U.S. 77, 2010. The Supreme Court explained that a principal place of business typically refers to a single location where a corporation's officers direct, control, and coordinate the corporation's activities, and in practice it should normally be the place where the corporation maintains its headquarters, provided that the headquarters is the actual center of direction, control, and coordination, i.e. the nerve center and not simply an office where the corporation holds its board meetings, for example, attended by directors and officers who have traveled there for the occasion. And that's in Hertz at pages 92 to 93 and page 96. Bankruptcy courts have looked to the nerve center test set forth in Hertz to make venue determinations. For example, this occurred in Silicon Valley Innovation Company, 2012 bankruptcy Lexus 4034 at star 6 through 8, and that's a bankruptcy case out of the Northern District of California, August 30th, 2012. In that case, the court found that the debtor's chosen venue was not proper. The debtor admitted that it had not maintained offices for a year and did not argue that it maintained offices in that judicial district at any time in the 180 days prior to the filing of its petition. Instead, the debtor argued that its mail was processed in the Northern District of California and that this made the district an appropriate venue based on a principal place of business test. The Silicon Valley Court disagreed and found that a mail processing location alone is not a debtor's nerve center or the place where debtor makes significant business decisions. The court suggested that the debtor's principal place of business might be in Florida, where the debtor, through its sole manager and employee, made significant business decisions. This court has also reviewed In Re West Coast Interventional Pain Med Inc. at 435 BR 569, pages 573 to 75, case out of the Bankruptcy Court in the Northern District of Indiana in 2010. In that case, the Bankruptcy Court followed other decisions holding that the principal place of business is a factual determination, and the inquiry should be where the entity's major business decisions are made and where its finances were managed, not where its day-to-day operations were conducted. Accordingly, the court in West Coast found it proper to focus on where the entity's key personnel made the major business decisions. With respect to the facts presented on this motion, the court finds as follows. Preliminarily, notwithstanding that both parties cite the nerve center test in their papers, movements focused their evidence primarily upon the location of GEM's offices and business operations, and not on what kind of business decisions for GEM were made or where they were made. GEM is a technology company. Before and into the venue period, its primary function was to raise funds to develop, maintain, and market a software application. At a certain point in the venue period, GEM's focus shifted from pushing a product into the marketplace to winding up a corporate entity that lacked sufficient funds to maintain operations. With respect to office locations, the parties tendered stipulated facts to the court at docket number 54. These stipulated facts included the following. At number 6, throughout the period of January 18th through September 30th of 2018, GEM had a lease of approximately 10,000 square feet of office space for 14 employees, including Gary Nerlinger in Garden City, Long Island, New York, which lease expired at the end of September 2018. Parties also stipulated in number 7 that in late 2018, GEM moved from space leased from WeWorks at 5th Avenue to lease space at a WeWorks building at 315 West 36th Street, New York, 10018. So these facts are not in dispute. And in fact, the court finds that most of the facts relating to office spaces, mailing addresses used by GEM over time, employee and CEO dates of employment, and job responsibilities for GEM's business not to be in dispute. James Massa, GEM's CEO prior to and during the venue period, tendered a declaration regarding the location of GEM's books and records. His testimony in the declaration was unrebutted. Prior to the venue period, Massa arranged for the storage of corporate records in electronic form for continued access from his home office in Kentucky. The declaration also states that hard copies of GEM's records are in a storage unit on Long Island, New York, which is not within the Southern District of New York. The parties stipulated to the admission of several email communications sent by Jem to stakeholders. Those emails list a mailing address for Jem on Long Island, located within the Eastern District of New York, until August 28th of 2018. And that's Movements Exhibit 9. All emails that Jem sent with a Long Island address were sent outside of the venue period. Emails from September 15th, 2018 through the petition date that were admitted to evidence also list an address for Jem at 315 West 36th Street in New York City, which is located within the Southern District of New York. And for example, see Movements Exhibits 10 and 31. In addition, other documents were introduced into the record, including the Jem Private Placement Memorandum and its supplement. And that's Movements Exhibits 35 and 36. Those documents identify Jem as having an address in New York City in October and November of 2018. There is also no dispute that Jem's communications to stakeholders did not identify a Kentucky office or any Kentucky address for Jem. During the evidentiary hearing, James Massa, now debtor's Vice President of Administration and a Director, testified regarding the New York addresses listed on these documents. He also tendered 2 declarations that were admitted as his direct testimony in connection with the hearing. Specifically, with respect to the New York City address, which is the pertinent address here based on Movement's contention that the case should be transferred to the Southern District of New York, Mr. Massa explained that using that New York City address was a matter of administrative convenience. He testified that several Jem employees went to the New York City WeWorks office location at West 36th Street routinely and were able to collect the mail there, including checks sent to the company, and process the mail. Massa explained that he worked primarily from his home office in Lexington, Kentucky, while serving in the CEO position, and that Jem employees also routinely worked from locations other than the New York City 315 West 36th Street location. Mr. Massa explained that it would not make sense to have checks for Jem sent to his home office or to the employees' homes. He also explained that having a New York City office address afforded prestige to Jem. He explained that the WeWorks facility access not only meant that Jem employees could use their desks at 315 West 36th Street location, but also that Jem personnel could use other WeWorks facilities for meetings. The court found Mr. Massa to be a very credible witness. The court specifically found Mr. Massa's explanation for why emails and other documents had a New York City address to be credible. The court found credible his description of the New York City office over time as a shrinking temporary office location maintained to ease or facilitate administrative corporate functions for Jem. The court also found credible Mr. Massa's explanations about his use of his home office in Lexington, Kentucky for purposes of running his consulting business, and that as a consultant he worked for Jem as its CEO from his home office. That Mr. Massa worked out of a separate office suite in his home does not mean that he did not operate as the entity's CEO from that location. And the fact that Jem did not lease the Lexington office space also does not mean that Mr. Massa did not function as Jem's CEO from that location. In fact, the court finds the absence of such a lease is not relevant to the nerve center test. The court also considered that Jem entered into a settlement agreement with a former attorney, and that's Movements Exhibit 44. Mr. Massa, who signed the settlement agreement for Jem, testified the agreement was drafted by the former attorney. That agreement, dated April 16, 2019, and therefore executed within the venue period, states that Jem has a, quote, home office in New York City, New York County, New York, end quote. The court finds that the existence of this document supports Movement's argument, but is not dispositive concerning where Jem's nerve center is located. A settlement agreement that references a home office does not, in and of itself, prove where key corporate decisions are made. No testimony was elicited as to where the party who negotiated this agreement on Jem's behalf was located during the negotiations or reaching the decision to enter into the agreement. The court also considered evidence presented concerning the SEC's involvement with Jem. Just prior to the venue period, an SEC judgment, Movements Exhibit 25, restricted how Jem could access funds throughout the venue period. Jem could no longer solicit investors. In addition, communications to stakeholders had to be reviewed by counsel, meaning Jem experienced additional administrative burdens and expense. Massa offered testimony about a meeting in March 2019 at which it was made clear that Jem could no longer solicit investments absent a waiver from the SEC. As a result, Mr. Massa explained that he attempted to formulate other options for Jem, including solicitation of a bridge loan and a potential Chapter 11 prepackaged bankruptcy filing. He also solicited loans from Jem's directors to meet operating expenses while he explored Jem's options. Mr. Massa attempted to locate bridge financing and consulted with bankruptcy counsel located in Lexington, Kentucky. At least one meeting regarding potential bridge financing occurred in Lexington. Further, Mr. Massa testified both at the hearing and through his declarations about the work performed by Jem employees. He explained that in his role as CEO, he was the ultimate decision maker for Jem. He formulated a change in business strategy during the venue period, intending to move the product from a consumer application to a business application. He explained that while it was his obligation to report to the Jem Board of Directors, and he did so, he oversaw or formulated the management strategies for Jem and oversaw and participated in the execution of those strategies. Mr. Moss's role as decision maker persisted even as it became necessary to wind down Jem's business operations and consider options including bankruptcy. Mr. Massa made the decisions regarding the business model for Jem. He made the decisions on hiring and firing employees, and he personally let them go. The cash crunch Jem experienced starting in February and March 2019 period also led Mr. Massa to make the decision to downsize Jem's New York City office operations, reducing the leased office and meeting space. During the venue period, Jem's use of the WeWorks facility transitioned to administrative functions only. The parties stipulated that Mr. Massa traveled to New York and conducted work functions on 14 days between January and April 2019. He testified at the hearing about what he did for Jem during those New York visits. But his testimony was undisputed that he primarily worked for Jem as its CEO from his home office in Lexington, Kentucky, within the venue period. Attempts to discredit Mr. Massa's testimony regarding his time in New York, such as by noting a discrepancy in an email about when an SEC-related meeting may have occurred in the New York City area, were unavailing. The evidence presented supports this court's finding that Mr. Massa made strategic, operational, and financial decisions from Lexington, Kentucky during the venue period and as Jem wound down its business activities. As previously mentioned, he took steps to secure alternative funding sources from Lexington in the venue period. On Jem's behalf, Massa also consulted with professionals in Lexington, including Gordon Garrett, who performed outside CFO functions for Jem, and Brett Anderson and Ethan Turner, who took on sales roles. Mr. Massa also discussed trying to bring additional revenue into Jem during the venue period, working with local consultants by instituting pilot programs with businesses in the Lexington, Kentucky regional area. Mr. Massa reported regularly to the board during the venue period. He explained that nearly all meetings were conducted virtually rather than in person, with directors spread throughout the country from New York to Texas to California to Kentucky. Although the board was required to vote on certain corporate decisions, such as the decision to file bankruptcy, this does not mean that Jem had principal places of business wherever the directors were located. Rather, as the entity's chief executive and essentially its sole ultimate decision maker, Where Mr. Massa was located in making decisions during the 180 days preceding the filing of the petition is central to the determination of GEM's Nerve Center. The court also heard testimony from Michael DiStefano and reviewed the declaration with his direct testimony submitted prior to the hearing. The court also found Mr. DiStefano to be a credible witness, including with respect to his explanation of his job functions, where he performed work for GEM, and his own understanding of GEM's business locations. But Mr. DiStefano conceded that, to the extent Mr. Massa engaged in conduct as the CEO from Kentucky, that he had no personal knowledge of what Mr. Massa did. Mr. DiStefano was employed by GEM for only a limited period of time during the beginning of the venue period. In addition, his cross-examination confirmed that he was not the decision maker for GEM, even with respect to matters connected to the scope of his employment. Specifically, although he was the Director of Investor Relations, he did not have authority to lower investment levels prescribed in GEM's private placement memoranda without Mr. Massa's approval. Accordingly, to the extent Mr. DiStefano's testimony is that, quote, all functions of the company were conducted in New York and the company never had a Kentucky office at any time during my employment, which ended in February of 2019, end quote, the court finds that this statement exceeded the scope of his personal knowledge of GEM's business activities, and therefore this testimony lacked a sufficient foundation. The court also reviewed the declarations submitted by Mr. Nerlinger. GEM chose not to cross-examine him, so the court did not witness his testimony. In large part, Mr. Nerlinger's July 24, 2019 declaration attaches exhibits including the emails discussed above. The declaration offers Mr. Nerlinger's understanding about where GEM employees work and where its records were located. The court finds Mr. Massa's testimony regarding these issues to be more credible. This is due to Mr. Massa's role as GEM's CEO and as a director during the venue period. Mr. Nerlinger did not have a role at GEM other than as a shareholder in the venue period. The supplemental declaration Mr. Nerlinger tendered, dated August 8, 2019, identifies 4 videos that Mr. Nerlinger represented would demonstrate the nature of debtors' presence in New York. The court reviewed those videos. At least 3 of the videos depict events outside the venue period. The court has determined that they are not relevant evidence and therefore excludes those videos. Mr. Nerlinger's supplemental declaration also attached 2 other documents and did not contain any substantive testimony. Accordingly, this declaration is of limited use for the purpose of this hearing. In sum, based on the evidence presented and the testimony before the court finds that Mr. Massa was the primary decision maker for GEM during the venue period. GEM's principal place of business under Hertz must be a single location. It is the location where GEM's officers direct, control, and coordinate the corporation's activities. GEM's Nerve Center, its principal place of business, within 180 days prior to the filing of the petition, was in Lexington, Kentucky. Based on these findings of fact and conclusion of law, the court concludes that the Eastern District of Kentucky is a proper forum for this Chapter 7 case. Next, movements invoke 28 U.S.C. Section 1412A1, which provides that if a bankruptcy petition has been filed in a proper district, on the timely motion of a party in interest and on notice and hearing, the court nevertheless may transfer the case to any other district if the court determines that transfer is in the interest of justice or for the convenience of the parties. Movements have asked this court in its discretion to transfer this case to the Southern District of New York under this statute. And again, there is a presumption in favor of maintaining the debtor's choice of forum, and that is the citing In re Borden, Chems and Plastic Operating Limited Partnership, 2004 bankruptcy Lexus 1251 out of the bankruptcy court in the District of Delaware in 2004. The burden on this motion is on movants to prove that the transfer is appropriate by a preponderance of the evidence. And that's Heckinger Investment Company of Delaware versus MGH Home Improvement Inc. 288 BR 398 at 402 Bankruptcy Court, District of Delaware, 2003. There are no hard and fast rules that offer precise guidance for the transfer of venue, and the bankruptcy courts are left to a case-by-case determination based upon all relevant factors. In Ray Pine Haven Associates, 132 BR 982 at 988, bankruptcy case out of the Eastern District of New York in 1991. In the West Coast Interventional Pain case mentioned earlier, the bankruptcy court described the considerations which may be used to determine whether to transfer venue under Section 1412. Those considerations are: 1, the proximity of creditors of every kind to the court; 2, the proximity of the debtor to the court; 3, the proximity of the witnesses necessary to the administration of the estate; 4, the location of assets; 5, the economic administration of the estate; 6, the necessity for ancillary administration if bankruptcy should result. Courts also consider the impact of venue on regulatory authorities who can reasonably be foreseen to be involved in the case. With these considerations in mind, the court makes the following findings of fact. The parties offered limited proof with respect to movant's request to transfer venue to the Southern District of New York in the interest of justice or for the convenience of the parties. First, the petition reflects that there are multiple creditors from New York, as movants discussed with Mr. Massa during the hearing. But there are over 80 creditors listed on debtor schedules. Less than a quarter of them are from New York, and not all of those creditors are located within the Southern District of New York. Mr. Massa is the only scheduled creditor in Kentucky. Second, debtor's principal place of business is in Lexington, Kentucky. As can be discerned from the record in this case and as stated in Mr. Massa's first declaration dated August 2nd, 2019, the debtor designated Mr. Massa as its corporate representative and the individual responsible for performing the duties of the debtor in this case. Mr. Massa lives in Lexington, Kentucky. Further, he has stated by declaration, quote, from June 2018 through September 2018, I ensured that all corporate records from that office, by which he meant Jem's former office on Long Island, from Nerlinger's garage and in any other employee's possession were brought to that office and scanned into an electronic depository consisting of computer files, Google Cloud Drives, and Dropbox Cloud Drives. I had the scanned records placed in a storage facility in Garden City, New York on Long Island. Any legacy corporate documents not scanned into the electronic repositories and accessible to me via internet were moved to Lexington, Kentucky. Thus, there is ease of access to necessary records in this case in Lexington, Kentucky. And the storage space to which Mr. Massa references is in Long Island in the Eastern District of New York, not the Southern District of New York. Third, as previously noted, debtor's corporate representative lives in Lexington, Kentucky, and the witnesses did not, strike that. The parties did not identify other witnesses necessary to estate administration. Fourth, this is a Chapter 7 proceeding. There are limited assets to administer. There was no evidence presented that there are any assets located within the Southern District of New York. Mr. Massa stated that he opened a bank account for processing payroll in Lexington, Kentucky. Fifth, as to the economic administration of the estate, Mr. Massa stated in his initial declaration that he is serving as Jem's corporate representative in the bankruptcy and that the debtor does not have funds to pay him to participate in a Section 341 hearing in the Southern District of New York. That testimony was unrebutted at the hearing and in fact is supported by debtor's schedules. The court also notes that the appointed Chapter 7 trustee in the Eastern District of Kentucky has engaged counsel to represent the estate's interests, and the court has approved that engagement. 6, no party put forward any evidence regarding considerations surrounding ancillary administration. Based on these findings of fact and conclusions of law, movements have not met their burden. The court will not exercise its discretion and declines to transfer venue of this bankruptcy case to the Southern District of New York. The court will enter an order to this effect later today. And that concludes the court's ruling. Are there any issues from any of the parties? Hearing
Thank you, Your Honor. Thank you.
Hearing none, court's adjourned. Thank you all.
Again.
Thank you.